episode number 53 of the Inland Empire Workers' Compensation Lawyer Livestream podcast. My name is Attorney Alexander Napple, and I'm joined by my co-host, Attorney George Abuado. And on this episode, we're discussing why your workers' compensation payments may have stopped.
Right.
There's all types of different reasons they may have stopped, and you listen to this episode and get a little insight into why. It's going to give you some education. It's general information only. It's not legal advice. If you need legal advice, call our injury helpline. It's 844-984-8414. What are we talking about today?
We're talking about benefits, and particularly today in specific, we're talking about temporary disability benefits.
Okay.
As you know, and as we've discussed before on this podcast, temporary disability benefits are benefits that are entitled they're entitled to you by the insurance company when you can't work, when the doctor has said that you are not able to work, and therefore, because you're not working, you need to get paid while you're off of work from your work injury. So the reason why this topic is so important, Alex, and the reason why I'm particularly excited to discuss this today is because a lot of people don't understand that although you do have temporary disability benefits and they might have began, they can be stopped for certain reasons. So you do have a job to do in order to keep them going, although you're not working, right? But your job is to make sure that certain things happen in order to keep these benefits coming to you.
If you're injured, you're off of work.
Right.
You're receiving workers' comp benefits, temporary disability benefits. That's what you get while you're getting better.
Right. Suddenly
They stop. That's, you got to do certain things to keep them going, like go to the doctor, right?
That's one of the things. So let's talk about four of the main reasons why they stop. Okay, people don't understand that once they receive a letter from the insurance company, kind of warning them, "Hey, your benefits could stop," or sometimes they just give you a letter saying your benefits have stopped, and they tell you why. There's a couple reasons. One is something that we'll talk about later. It's you agree that they stop, okay? And how do you do that? Why would you want your benefits to stop? That makes no sense. However, if you choose to settle your claim via compromise and release, a settlement that settles everything out, then of course you're getting paid a lump sum and the claim is over. You're not going to have any more benefits left over. It's not like you're going to settle your claim, you get paid all that money, and then they're going to keep on paying you. That doesn't happen, right? I've never seen that. Have you?
No, if you settle out for a lump sum, that's the insurance carrier buying out all the future liability on your claim, and that includes all ongoing payments.
Correct.
So it's a compromise and release.
Compromise and release. So that's the first way they can stop. The second way they can stop is if a judge orders it. So the insurance company, through their attorney of record, the defense attorney, they could file a petition for a number of reasons. If they're asking for the benefits to stop and the judge grants that, then your benefits will stop by court order, right? So
why would they do that? Why would a judge order that the benefits stop?
Well, there's a plethora of reasons, but one of them could be maybe you're not complying with the certain things you should be doing in order to receive those benefits, right? So maybe you're not going to your doctor's appointments on time. Work status reports aren't being issued in a timely manner, and that's one of the reasons. Another reason, it could be something as out of this world as they find out that you're committing fraud.
Right.
Right. So if there's a possibility and the defense alleges that you're committing fraud and the judge looks and there's good reason to believe that this might be true, it's not like they're going to convict you of fraud right away or you're going to get penalized immediately, but they might be able to get the judge to issue a stop benefits order in order to examine more whether or not there is fraud being committed. Just a couple of the reasons that might happen, right? Maybe you missed a very important exam. A med legal exam, as we call them, a QME, qualified medical examiner, agreed medical examiner, a very big examination, evaluation. You missed it. You should have been there. You didn't have a good reason as to why you missed it. The judge might order that until you do show up for your next evaluation that's been rescheduled.
Right. If you don't have a good reason to miss your med legal evaluation, which is the QME, which we've discussed on this channel before.
Right.
We'll put a link to that right up in the corner up here so that you can go ahead and learn more about what the QME is. If you've gotten a notice for a QME and you don't go to it, the insurance company could ask the judge to stop payments, stop benefits for you.
That's correct.
And of course, the judge isn't assigned to your case unless you have a lawyer usually,
right?
Because you got to have a lawyer before you file a workers' compensation appeal, and that's what puts the judge on the case. But if you have a lawyer and you choose not to go to that QME, they'll just stop paying you. Potentially, you got to have a good reason. I mean, you could have a death in your family. You could have a very legitimate reason. You could have COVID. There's a lot. You could get a doctor's note to say, hey, I can't attend. But if you just decide to blow off your med legal evaluation, and especially if you do it twice, defense is probably going to move and file a petition with the workers' comp judge, have the workers' comp judge ask them to suspend your benefits until you go to that exam. It's very painful if you do that to yourself.
Yeah, and you have no one to blame but yourself. Pro tip, always attend scheduled events. And by events, I mean your deposition, extremely important. I mean, there's a lot of money that goes into that, not out of your pocket, but for discovery by the defense, which they can actually ask the judge to have you pay back out of your benefits. Always attend your depositions. If you can't, please let your attorney know ahead of time. Or if you have a really good reason that day, if you got in a car accident on the way to the deposition, obviously that's an event that would supersede the deposition. But if you have a scheduled event, whether it's a hearing that you need to attend to, if your attorney told you that you don't have to show up, that's different. But if you have to attend to a trial, a hearing, a deposition, a medical evaluation, please make sure you do. That's just a pro tip.
Yeah, I think they could suspend if you are refusing to go to your deposition too.
Yep,
like
that's
if you're just missing your deposition over and over again, I think that the defense could probably ask the judge to suspend benefits too.
Yeah, and being scared of your deposition is not a good reason to miss. First of all, you shouldn't be scared of a deposition.
Everyone's going to be a little nervous.
They're going to be a little nervous, but what I tell my clients, Alex, is listen. I know that you're nervous, but there's no reason to be. I've done this 1,000 times, and I can tell you right now, I'm going to prepare you really well. And they're only asking you about things you already know about. It's like going into a test about subjects that you know everything about. So I know it could be a little intimidating with an attorney there, a defense attorney there, a court reporter, things like that. But, that's for another day.
We've mentioned deposition. It's something you have to do once you have a lawyer, you file a claim. Most applicants, most injured workers have their deposition taken.
Yeah.
So the defense attorney, the attorney hired by the insurance company, wants to ask you all types of questions under oath. Those things are all written down by a court reporter, and that establishes your side of the story for the claim.
Right.
For the most part, these cases don't go to trial. If they do, the deposition can be used to impeach you, but it's generally used to send to the QME. It's generally used to establish your side of the story. You can't be afraid of doing that because you're an injured worker asking for benefits. Go to your deposition and tell them what happened.
And if you have a good attorney that's done thousands of depositions like Alex and I have, we'll prepare you really well on the day of the deposition. You will have no doubt in your mind about how to answer questions, how to deal with the questions that they ask. So really not a big deal. But getting back to what we were talking about, there's another 2 reasons why they could stop, Alex. Number one is, as you know, there's 104 weeks of TD that's payable that an injured worker can receive. After that, it just stops, just because you've exhausted your 104 weeks.
Right, and because in injured workers, it takes so long to get your medical care if you need a surgery. I mean, you can get but you can get to that 104 weeks and you still haven't had your surgery.
Yeah,
it's a tactic that the insurance company will use, to exhaust you.
Right, and the last reason, a very common reason, I think actually more common than the ones we've spoken about, is your return to work. So you return to work. Maybe you don't return to work, but a doctor declares you to have reached maximum medical improvement or be permanent and stationary, which means that you are no longer entitled to receive your temporary disability benefits. So let's talk about each one of these things. Let's talk about an accepted claim first, okay? An accepted claim, once you are injured, you have to designate a primary treating physician. That physician is going to be the one that's in charge of your medical treatment throughout the life of your claim. Now, with an accepted claim, most of the times there's a medical provider network, and we need to pick a doctor within that network. Once you pick that doctor is responsible for providing all the parties with an updated work status and medical reports at least every 45 days. In my experience, it's actually the time period is shorter than that because, you probably see this doctor every 30 days, and that's when you're getting your work status, but at least every 45 days. So in 3 months, if you see a doctor twice, every 45 days, you need to provide a work status in order to keep getting on those temporary disability benefits.
That's important to know.
Yeah.
Because if you miss an appointment and it takes time to get in to see your doctor again, you might go past that 45 days.
Yeah.
Potentially.
Yeah.
Now, will the adjuster keep those benefits on? I've had these situations where my client comes to me and they're being threatened that their benefits will be turned off.
Yeah.
That's why they're getting a lawyer. It's maybe why you're watching this episode we put together. we'll go in and we'll select a new physician, or we'll tell the adjuster, hey, we got an appointment in 5 days from now. You better keep those benefits on because there's no change in status here.
Yeah.
And a lot of times, actually pretty much every time, I can get those benefits continued.
No, you're absolutely right.
But
Alex.
if you're just an injured worker on your own, they're just gonna the adjuster's gonna lay the hammer down on you. It's be like, nope, sending out the notice, you're burned.
Yeah, and it could be for something as simple as, like we've said, missing your doctor's appointment. Now, I've had all kinds of stories where people just don't go for the dumbest reasons, Alex. I'm not going to get into those reasons, but maybe the sun just wasn't shining that day and they didn't feel like going to a doctor's appointment. What people don't understand is that your medical treatment is the lifeblood of your claim. If you're not getting medical treatment, then there's no reports that are going to back up your injury. And there's no reports that the neutral doctor, the QME, AME, is going to be able to look at and say, okay, they have been receiving treatment for this long period of time. They are injured. If you just constantly miss those doctor's reports, not only are your benefits in danger, but also your claim as well.
Yeah, medical treatment's imperative. Yeah. You need medical evidence to establish your temporary disability entitlement. Every benefit entitlement comes from and grows from the medical treatment reports.
Now, I'll throw in another pro tip. If you had applied to EDD before your claim was accepted and you started receiving TD, and you reached those 104 weeks, which is the cutoff for the TD, after that, if the doctor is still saying you cannot go to work, you can go back and try to obtain EDD benefits again. So you can go back to your EDD claim that you filed back in the beginning, and you can request temporary disability benefits through the EDD department.
This is something that George was telling me that he has all of his clients do. You have all your clients apply for EDD right away. Start their benefit, or at least establish their entitlement to the benefit, the state disability benefit.
Right, because you have that delay period where they might not be paying benefits. They're still trying to figure out what's going on with the claim. Okay. They have to provide medical treatment up to the $10,000, but they don't have to provide benefits.
And that's the 90-day delay period, right?
Correct.
So like you get injured, your employer sends you to the doctor, you get a letter in the mail that says, hey, your claim's on delay. During the 90-day delay period, while they're investigating whether or not you got hurt at work, or if they don't have to pay you temporary disability benefits. So you got to apply for state disability. That's through the Employment Development Department. If you've been working consistently, you have money in there. It's the same amount. It's the same rate as temporary disability through workers' comp. It's 2/3 of your gross pay, up to a certain maximum, which I don't have off the top of my head, but we'll put that in the comments below. If you're interested in knowing what the rates are for temporary disability, put that in the comments. We'll put a link to that and to the EDD website.
Yeah. And it's important that if you do have questions, please reach out to us, because by no means is this an exhaustive list of things that could happen where you get your benefits taken away. I mean, something could happen to where maybe you're a seasonal worker and your season has ended. Therefore, you wouldn't actually be working during the period of time because it's not the season. So now they are no longer on the hook to provide you temporary disability benefits. Or what if you're getting temporary disability benefits, you're still an employee, but you get fired because they find out that you have committed some type of fraud during your employment, or some issue happened during your employment. If you are fired from your job, you are not entitled to temporary disability benefits.
Right. Yeah. If you're let go for a valid reason.
Correct.
They'll deny your temporary.
At that point, I've seen a lot of people apply for unemployment, but
Well, if you're too injured to work, maybe you're going to want to apply for state disability.
Yeah.
It depends if you have an injury and then you're also let go for some other reason. One of the things that insurance companies like to do is they like to send you to their clinics, and their clinics don't take you off completely for your injury. They give you work restrictions. So then you get terminated for some other reason, and they say, well, if it wasn't for your termination, we'd be able to accommodate you, and therefore we don't have to pay you temporary disability benefits.
Yeah, and while we're on this subject, Alex, I just thought of something that you might have come across as well. I have a lot of clients that ask me, hey, these are my restrictions, and my work is saying that they can accommodate me. Do I have to show up for work? What's your answer, Alex?
Yeah, you got to show up. Absolutely.
Got to show up. Please, please, please understand this. If the employer is giving you what's called a modified work through a modified work offer, okay, these are all terms of law within workers' compensation, but modified work, that means that they can accommodate you. That means that whatever your doctor is saying you can't do, you don't have to do it. They will accommodate those restrictions. What you don't want to do is say, no, I don't want to do that. I'm going to stay home, because guess what? Then they don't have to pay you temporary disability benefits at all. If you do feel like you're too injured to work, even though they're accommodating the restrictions, but you feel like, hey, even those restrictions are not enough, I still can't do all this other stuff, even if the doctor says you can, what you can do is you can go to work for a while. If you feel like you can't work anymore, go to a supervisor, go to a manager, tell them, I tried to work and the pain is just unbearable. Can you please send me to the doctor?
Yeah, that's very smart.
Yeah.
That's good advice. I mean, it's not advice. This is general information. If you need legal advice, you dial the injury helpline. That's 844-984-8414. But yes, if in general, you don't want to not show up, because they're going to terminate you for no call, no show.
And it happens so often,
does.
Alex. And people just don't understand this. Please understand how to keep your benefits. That's why I wanted to do this video today. Yeah, for sure.
You need to know why your benefits might stop. So we hope we've given you a little bit of insight into that. It's general information only. If you're just listening to something online, it's not tailored to the specific facts and circumstances of your case. It's general information only. It can help you understand what's going on. It can help you have a better conversation with the lawyer that you decide to hire or that you have, but it's not legal advice.